point. That's all I have to say, unless you have any questions, Your Honors.
Very good. Thank you. I see no further questions. Thank you. The case is submitted. Case number 6, Doe versus Garcia and Wal-Mart Associates, Inc. The panel for this case is Justice Fuhrer, Justice Stone, and me, Justice Martinez. And Ms. White, you get to go first.
Good afternoon, Your Honors. Thank you. I represent the plaintiffs, Jane Doe and Jane Roe, in this action. This case is about whether the jury was given the law and the evidence necessary to decide the truth fairly. And the answer is no. The trial court distorted the trial in 3 ways that work together. One, the trial court misframed the law, especially on the hostile work environment and harassment claims, forcing plaintiffs into an overly narrow instruction and verdict form, asking whether they were harassed because they were women, instead of allowing the jury to decide whether the workplace was hostile because of sex and sexualized conduct. The second way was the trial court excluded or limited critical evidence, including time-stamped phone records, impeachment evidence against Mr. Davenport, and pattern evidence involving other women and workplace dissemination of nude images. And third, the trial court did so in a process that repeatedly described and was constrained by time and workload, showing that procedural efficiency was allowed to override the careful, fair development of the issues. The facts that the jury needed to understand: Florence Washington, who was Jane Doe, and Santana Glasgow, Jane Roe, they worked in a highly invasive kind of sexualized workplace, including nude photos that were circulated amongst Wal-Mart employees. Miss Washington was called a whore. Her body was weaponized against her in the workplace. Miss Glasgow reported what she saw, including Miss Washington's intimate photos on a coworker's phone. And Miss Glasgow herself was subjected to sexualized misconduct, including, I hate to use this before the court, a dick pic or penis photo, and also an incessant sexual commentary from Solaris. The evidence viewed as a whole showed a workplace culture involving sexual misconduct, the circulation of intimate images, sexual commentary, racial slurs, flawed investigations, and fear of retaliation. There was evidence that Mr. Davenport had slept with or solicited nude photographs from multiple female employees, including Florence Washington, Ruthie Martin, and Miss Flowers. That is in the record, and I have the specific citations that the court wanted. There was also evidence that Solaris obtained Miss Washington's nude photos, threatened to post them, showed them to others, and called Miss Washington a whore. Witnesses testified that the photos were passed around or discussed in the workplace. This matters because this was not a private interpersonal spat. It was evidence of a sexualized workplace environment.
So, Ms. White, it would be helpful. So you raised some issues that would be helpful. I understand you're reciting the evidence. You should assume we're familiar with the record. But if I can ask you about the jury instructions, because you started there.
Yes.
And you raised that in your brief. So with respect to the hostile workplace, I'm looking at Casey 2522A and 2523, which are on the record at 10590 and 10591. So you argue in your brief that the problem with 2522A is that it uses as the second factor that plaintiffs were subjected to harassing conduct because they are women, which is, I assume, what you're referring to. So I'm curious, in that instruction, it refers 2 times to harassment based on sex, and then on 10591, which is the 2523, what is harassing conduct? It talks about harassment, and it includes sexual conversations, obscene language, sexual remarks, offensive pictures, etc. It's not clear to me why that would be confusing. In other words, the jury found, as you know, that it did not find that Solaris had distributed nude, or at least had intentionally distributed nude photos. But it's not clear to me with respect to the finding against Ms. Washington and Ms. Glasgow with respect to the harassing conduct, why the use of women in paragraph 2 would have been confusing given all the references to sex and sexual things.
Well, Your Honor, the court insisted upon Cassie's 2521A and 2522A requiring the plaintiffs show harassment because they are women. And what we argued was it wasn't because they were women, it's because of sex. That was the more appropriate construction of the law and of the jury instruction, because what the court and requiring us to place because they're women is a very narrow gender-focused target for the law, because both men and women, if they worked in that environment, it was hostile. You know, it didn't matter whether they were women or men, it mattered because of sex. And that is what was the distinction and what was so confusing for the jury. The special verdict form repeated the error and asked if Washington and Glasgow were harassed because they were women. But as of 2025, the wording of the Cassie had changed, not for the reasons that apply here, but because of the plaintiff is perceived to be a member of a protected class. So Cassie 2521A and Cassie 2522B, it required the plaintiff to prove that they were members of a protected class, but here the plaintiffs were members of a protected class, and the court imposed an additional unnecessary and ultimately highly prejudicial element. And we argued for instructions that the harassment was because of sex that aligned with the FEHA statute. Sex is a separate protected category under Section 1, Government Code Section 12940, subsection A. And the improper instruction in the special verdict form effectively, it ended the plaintiff's hostile work environment claims and otherwise prejudiced their case.
Right, but I guess what I'm trying to understand for you to help me with is I understand your argument that the second element required harassing conduct because they are women instead of what you had argued because of their sex. But if harassing conduct is explained to include sexual remarks, sexual conversations, and offensive pictures, it's not clear to me, since, for example, with respect to Ms. Washington, if she is a woman and is feeling harassed because she is being, well, let's say Ms. Glasgow is being shown nude photographs of Washington and is subjected to Solaris, as alleged, having inappropriate sexual conversations with her, making sexual remarks. If those things the jury found happened, given that the definition of harassing conduct includes those then why would it make a difference that the second element requires harassing conduct because of women? It would seem to me it is her. It's, in other words, if harassing conduct is defined to include sexual conversations and pictures, why does it matter in terms of the verdict form that it refers to harassing conduct because they are women?
Good question, because it's significant, Your Honor, because the error was not merely semantic. The defense seized on it an argument, and they told the jury that the plaintiffs were not harassed because they were women. And that became a theme and the death knell to their case. That means that the instruction in the verdict form, it did exactly what a prejudicial instruction does. It gave the defense a distorted legal lens and invited the jury to reject a valid harassment theory by focusing on the wrong question.
But weren't they making that argument based on the fact that their contention was that there never were nude photographs and that the accounts given by Ms. Washington and Ms. Glasgow were not accurate? I don't think it was so much that they're saying they were not harassed. The harassment, in other words, I don't read that defense counsel was making the argument that the harassment was on the basis of sex, not gender, well, because they were women. It was more that there were no nude photographs or improper comments that were made that would create a hostile environment.
Well, there's a recent case that stated that the circulation of nude photos in and of themselves that is a hostile work environment. And that, based on the court's recent clarification of the interpretation of the fiat, that's been squarely resolved. And
I'm not suggesting otherwise, passing around nude photographs. I'm saying that the argument was that they weren't passed around, more than that the jury should fine for Wal-Mart because it wasn't harassment based on their being women as opposed to sex.
I'm a little confused as far as the court's question, but I hope I'm addressing your question directly. There were a lot of things in this case that constituted a hostile work environment. And it wasn't just with respect to the circulation of nude photos. It had to do with sexual talk. It had to do with escapades. It had to do with, Mr. Davenport dating multiple women in the workplace, and not just, that location, but it also took place at another Wal-Mart location as well. And it involved the same HR and it involved the same management. And in the context of the company or corporation knowing that this was taking place and nothing was being done about it. And so the prejudice standard, it comes from the Kassim case, Your Honor, where it states that it's reasonable probability means a reasonable chance more than an abstract possibility. And, it assumes that the jury might have believed appellant's evidence. But in the situation here where the evidence was so constricted and eliminated from the jury hearing it in a skewed manner, it was impossible for a fair trial to be had, even with the jury instructions here, the language not being accurate, but also even with the ones that the court flat out refused to give to the jury, which was the 25-21, it was 25-21B and 25-22B, harassment of others.
So at this point, you're at 14 minutes. Do you want to address the other 2 points that you raised? And you may use up your time from rebuttal if you want to continue arguing.
Oh, sure, Your Honor. I forgot where it was. So I was talking about the prejudice from the wording of the actual instruction, and there was nothing to cure the instruction. And as I said, the defense, they exploited the language and argument in before the jury, which is classical prejudicial instructional error. Also, there was an argument that the environment was highly sexualized, women's bodies, and used as objects of humiliation and circulation. And men and women alike were subjected to that environment. And that's not a departure from the FIHA, that's direct application of the FIHA. And counsel tried to distinguish the Lyle case in their written brief, but Lyle was different because Lyle involved conduct tied to workplace content creation, which is different from employees who are working at a Walmart. And as I stated before, the harassment of others instruction, it was not given, although the plaintiffs presented evidence of harassment witnessed by others and evidence that the workplace environment was hostile, as multiple people had observed the conduct. And Ms. Washington and Ms. Glasgow, they had lived in that environment. They worked in that environment. And this was especially important, the 2521B and 2522B was really important to Glasgow's case because her case depended on substantially on what she witnessed and what was shown to her and how the workplace operated. And this was a credibility case that was pointed out in the respondent's brief. Even their position, was that it was a credibility issue, but there were various things that impinged on the plaintiff's rights to show or prove their case, which is number one, the phone records. The court excluded the cell phone records. Those are identified in Exhibit 145, and they showed communication with Davenport on the date and time the nude photos were sent. And then the record.
And I have a question for you. Were those photos turned over in discovery? Isn't that the reason the court gave for not allowing them in?
The court did give that as a reason for not letting them in, but at the point where we used the phone records, they were being used for impeachment, Your Honor. They were not being used for the purposes for which the court had some type of evidentiary sanction. They weren't. The records were being used to prove critically that the timing, the sequence, and the communication patterns that corroborated Ms. Washington's version of events and undermined Mr. Davenport's denial. Surely he knew he had received text messages, and surely he knew of his phone records. But at the point in time where the case is about credibility and he gets on the witness stand and he lies about having engaged in the texting communications, those phone records become very critical as far as impeachment.
But can I ask, I understand your argument in terms of impeachment, and it is typically the case if a document is not on a party's exhibit list, they can still be used for impeachment. But in a situation like this, where the other side, where Wal-Mart specifically requested documents relating to communications, and Ms. Washington and Ms. Glasgow do not turn over in discovery phone records, which you're trying to use to show there were text messages or communications between between Ms. Washington and Davenport. So that was directly relevant, that was directly responsive. It's not clear to me how the fact that it's used for impeachment gets means the court abused its discretion in saying you should have turned it over to discovery. It's not fair to show this for the first time at trial.
Well, the specific request was not made for phone records, but the issue and the distinction here is it matters because the records were offered for impeachment once Davenport denied receiving or sending the photos. They became crucial when credibility crystallized. In a credibility case, impeachment evidence, it's not collateral. The records were not offered to prove every element by themselves. They were offered to contradict the denial witness and to corroborate the timeline. I don't know if I answered. Should I continue? Do it. Sorry.
Yes. No.
Oh.
You can go ahead.
Okay. The other issue that came up was the felony conviction issues. And the court excluded the evidence of Davenport's prior felony convictions, including armed robbery and issues of perjury. And more importantly, the evidence showing that he lied about his criminal record to his employer, Wal-Mart, to his attorneys, and the court. And this is a very huge issue because the criminal convictions, they went to the weight, not the admissibility, particularly where the witness's credibility was crucial. And a revenge porn type of case where the witness is saying he didn't disseminate photos, he didn't receive them, or whatever. His credibility was crucial. And the convictions, they weren't standing alone. They were tied directly to an employment application and an employment case in which we would have been able to show that he lied about his felony convictions and his background. He even lied about the way he spelled his name. I mean, these are like issues that made it very difficult for the plaintiffs to present their case.
And was the employment application an exhibit?
Yes, it was, Your Honor. And then there was issues concerning, sorry, I have a lot of papers here. Then there was the issue of the evidence about differential treatment as far as the handling of the murder of Miss Washington's partner, and that the court had precluded in a motion in limine. And this goes to the broader fairness argument where the court applied a evidentiary restriction as to the plaintiffs, but allowing the prejudice to seep in as to the plaintiffs. The other issue was there was some pattern and practice evidence that was not allowed to be developed. The issue was with Ruthie Martin, who was one of the women who had similar conduct committed against her. And the defendants made repeated targeted efforts to exclude Miss Martin's testimony and other employee complaints about such evidence. And the appendix, it shows in the Wal-Mart's motion in limine number 8, Wal-Mart motion in limine 7, motion in limine 6, and that the opposition that the plaintiffs filed in regards to motion in limine number 7, the record showed that Ruthie Martin had related complaints concerning what she experienced as to Davenport and Solaris in the workplace, similar to Ms. Washington. And this was raised in the motion for new trial documents. But we were limited to Me Too evidence. We were limited in the Me Too evidence from witnesses like Trevetta Jenkins, Ruthie Martin, Matt Rickett. The court would sustain objections about hearsay. And the point is that the evidence was not being used to prove the truth of the matter asserted. The evidence was being used to show just how sexually charged the work environment was and how sorry
to interrupt, but can I ask, I thought Ruthie Martin did testify. Didn't she testify that Solaris threatened her with nude photographs? I thought she's the one who came in. You had you have complaints about Ms. Flores and others, but I thought my recollection was that Ms. Martin did testify about that Solaris threatened her with nude photographs.
She did testify, Your Honor, but it was in a fragmented manner. She didn't fully testify, and the court limited her testimony based on the motions in limine that the defense filed.
So she couldn't testify about what?
Specifically, the pattern evidence of was undermined in the motions in limine and the hearsay rulings.
I can look it up if you want, because I don't want you to use all your time on that. But
I'm sorry, Your Honor. I could find it, but it would take time for me to go for the record to find it for you.
Not a good use of your time.
Yes, and speaking of your time, did you want to address the limiting trial? I think that was the third point you raised in your opening, because you're at approximately 26 minutes of your time.
Sure, Your Honors. The limited trial issue. Sorry, I'm just trying to. Oh, Your Honors, as far as the instructions, there was also an issue as to the negligence and negligence per se that was improperly given to the jury. I forgot to notate that. And so the due process arguments regarding the time limitations, I repeatedly asked the court for more time, and we were basically restricted. And the court applied the Crane case, but the Crane case was not, is not on point to the circumstances where both sides are not given an opportunity to present a fair trial. And I continue to object, saying that I'm not allowed to cross-examine defense witnesses, especially their expert, Mr. Hinken. And if the defense is presenting their case in chief and I can't cross-examine the witnesses, it undermines the purpose of even having a trial. And it becomes a significant due process argument, because the defense can get on the witness stand and they can say whatever. And then the plaintiffs cannot cross-examine the witnesses.
Was the expert that you couldn't examine, was that the expert on damages? What was the expert on?
That was an expert on, it was their Dr. Hinken. But there were several witnesses that if Your Honors look in the record where I said, motion to strike, plaintiff is not allowed to cross-examine each time, and the court denied the motion.
Right. My list for my notes is Leahy, Johnson, and Walter. From looking at your brief is my recollection, who were store managers, but it seemed like their testimony was about what discipline that Washington and Glasgow had, as opposed to other testimony. Is there something
Well-
specific that they testified about that would have been, I mean, I understand you are making a point that you didn't have enough time to cross-examine. I'm just wondering what specifically about their testimony was damaging not to be able to cross-examine.
Well, in a trial in a truncated way, when you're racing against the clock and the court is basically saying, and it was in the record, even earlier in the case before the trial, the court commented about, how the court had spent 8 hours on the matter, how he had a jury coming in. The court stated, please don't give me briefs. I don't have time to read them. Things of that nature. It becomes a miscarriage of justice and a due process issue when the parties don't have sufficient time to present their case, and they're constantly being told that they've run out of time, where you have two plaintiffs, multiple causes of action, and the plaintiff is being restricted and not having enough time.
Were there particular things that the witnesses Lehigh, Johnson, or Walker testified to that you felt were kind of damning to your case and that you couldn't challenge?
Yes, I do. I don't have it at my fingertips, but maybe when your honors come back to me, I know I have it here in my notes. I just can't locate it right in this moment.
Very good. So at this point, you've exceeded your total time estimate, but you will have some time for rebuttal, but we do need to hear from the other side now. So, Mr. Dixler, you're up.
Good afternoon, Your Honors. Scott Dixler for Wal-Mart. Your Honors, I'm going to start with Justice Fewer's line of questioning to my opposing counsel about the jury instructions. The harassment claim that those instructions pertain to fails factually and legally. Factually, as Justice Fewer noted, the jury found in connection with the revenge porn claim, which has nothing to do with any harassment instruction, that neither Davenport nor Solaris intentionally distributed nude photos of Ms. Washington. So that finding, which isn't challenged on appeal, eviscerates the basis of the harassment claim. So even if the instruction were erroneous, and it wasn't, a showing of prejudice would be impossible. Now,
Well, I'm just curious. The jury instruction asked if they intentionally distributed the photographs, and the jury, as you know, said no. Does that mean they were not distributed?
yes, under the facts of this case, there's no, well, let me break it down in between Davenport and Solaris. So Davenport really wasn't accused of doing anything with respect to the nude photos. The plaintiff's counsel at times in the trial speculated about how the photos ended up in Solaris's hands, allegedly. The jury found that she didn't distribute them anyway. So the jury presumably found she never got them either. But there was no allegation that Davenport himself spread the photos. So theoretically, could the jury have found, well, maybe he inadvertently left his phone laying around and then Solaris got her hands on them? Yeah, maybe the jury could have found that. But the key to plaintiff's case was that Solaris then was the bad actor who showed the nude photos that Washington had sent to Davenport, allegedly, to Washington herself and then to Glasgow. But the jury found that that never happened. And that finding, which is amply supported by the evidence, not challenged on appeal, that killed the harassment claim. It killed the factual predicate of the harassment claim.
Well, part of it, because there also were allegations of sexual comments and discussion of body parts and other things. I mean, yes, that was certainly a major part of the case, but there were other aspects.
There was other testimony that I think if you review the record as a whole, the centerpiece of the trial was this nude photo testimony.
Weren't there also someone else named Phillips showed a photo?
Yes, although Ms. sorry to interrupt you, Honor.
No, but weren't there? It wasn't
there was
just
testimony about that, but if you look at the evidence about that, Mr. Phillips, there were texts to Ms. Glasgow where Mr. Phillips was showing sexually explicit images to Ms. Glasgow, but the testimony was not that she found that upsetting. She just testified about it and they were engaged in kind of a friendly banter about it. The testimony wasn't that she saw that and that was devastating and she needs damages for that. And it's notable that she didn't sue Mr. Phillips. She sued Davenport, Solaris, and Wal-Mart. So she wasn't, plaintiff's counsel argued that that was evidence of the sexualized workplace, and the judge incidentally allowed her to get into that, even though it had nothing to do with whether nude photos of her were spread. So that contradicts the argument that this was a trial somehow free of Me Too evidence. There was evidence, there was marginally relevant evidence suffusing the trial. But on the instructional error point, there was no instructional error. The plaintiff's counsel is conflating separate requirements in FEHA. FEHA requires harassing conduct, and as Justice Fuhr noted, the jury was instructed that the sexually explicit material could be harassing conduct. That's true. It requires that the plaintiff be a member of a protected class. Here, the only protected class at issue is sex or gender, i.e., their status as women. But what plaintiff's counsel is blowing by is the requirement that the harassment be targeting the plaintiff on the basis of the protected status. So it's not just I have experienced harassment and I am a woman. It is I have experienced harassment because of my membership in the protected class, because I am a woman. And that's why the cases talk about the FEHA is not a civility code. It's not meant to stamp out all rude and inappropriate conduct in the workplace. And I don't question the fact that the conduct alleged, if it happened, was unacceptable. The problem for plaintiff, though, is that the jury was properly asked whether the conduct, A, happened at all, and they said it didn't with respect to the nude photos, but B, were plaintiffs targeted because they are women? That was the legally correct question, and plaintiff's counsel now concedes that they weren't targeted because they were women.
So you're suggesting that the harassment here, which the plaintiffs are characterizing as just kind of the sex-filled universe and being bombarded with sexualized images, it might be some kind of harassment, but it's not, doesn't fall within FEHA because it had nothing to do with their protected status.
That's exactly right. What the evil that FEHA is trying to root out is ultimately discrimination. It's unequal opportunity in the workplace. It's certainly true that a workplace that's suffused with sexual content, a jury could find that that is targeting women and trying to make women feel uncomfortable or show that they lack certain opportunities at work, and that's what FEHA is trying to root out. But when plaintiff's counsel is here conceding that, oh no, they weren't targeted on the basis of their protected status, everybody was shown this stuff. That sounds like a workplace that would be challenging to work in, but it's not a workplace that violates FEHA. Because what FEHA is aimed at is rooting out differential treatment of protected groups.
Well, but it could still be, I mean, I'm not sure we have to get into that. It could still be, you could have, FEHA is not just about discrimination, it's also about harassment. It could be women are in, if the facts supported the scenario where Ms. Washington and Ms. Solaris, and it's not for us to say they did or did not, but if the environment included where everyone's passing around photographs, and I recognize they were male parts also, but they were, female organs, and also talking about sex and talking about sexual conduct, and a woman feels that, she's uncomfortable in that environment, and it's purposeful and severe, et cetera, that could support a harassment claim without discrimination.
I agree with you, Your Honor. The issue, though, here isn't whether the jury on this evidence would have been entitled to find that she was harassed because she was a woman. The question is whether the jury was misinstructed that that was something that the plaintiff had to prove. And plaintiff's counsel's argument to the court illustrates why the trial court and why Casey in its generic instruction is right to use that or to recommend that because of language. Because when plaintiff's counsel says, well, harassment because of sex means harassment with sexually explicit material, that removes the requirement that the plaintiff be harassed because of the plaintiff's membership in the protected group. And that is a separate requirement under FEHA.
Let me ask, Ms. White said that Wal-Mart's counsel at trial argued that the plaintiffs were not harassed, made the argument that the harassment was not because they were women. I'm not sure quite what she is referring to.
I'm not either, Your Honor. As I stand here, I recall the focus of the closing argument being the same as Your Honor recalls, which is that it never happened. I don't want to say to 100% certainty. I don't have the closing argument completely memorized. Is it possible there was a sentence? Maybe I don't remember. But in any case, it was not a theme of Wal-Mart's defense. The theme of Wal-Mart's defense was that this didn't happen, and also that Wal-Mart, as the employer, did everything a responsible employer should do when confronted with this. That Wal-Mart took the allegations seriously, investigated it, interviewed witnesses, couldn't corroborate it, but then anyway encouraged Solaris to move to a different store and separated them. So that was the focus of Wal-Mart's defense.
Can I ask you about the employment application? I don't know if you had something else on the jury instructions.
No, I think that covers it, unless the panel has questions about it.
I'm not seeing anyone jump in. I guess I'm curious on the felony conviction issue. I understand the argument that because the convictions were so old, that the court, Wal-Mart's argument that it was not an abuse of discretion to exclude the felony convictions. With respect to the employment application, your colleague is arguing that it's different because that's not so old if he was lying on the application. Did the court specifically exclude questions about whether he lied on the application?
I believe so. As I stand here, and I'm not sure that this is in plaintiff's counsel's opening brief, but but as I stand here from my recollection of what happened at trial and reviewing the record, I do recall that issue coming up, and the judge didn't want to get into. I mean, the record will speak for itself on this. I'm going by recollection, right. But the judge didn't want to get into it for a couple of reasons. That first, because again, it dredges up those old convictions, and the judge had a broader concern with plaintiff's counsel's strategy to center her defense on the idea that Davenport is just a bad guy who does bad things. And that's where plaintiff's counsel and the court sustained objections to this, asked Davenport, how many women have you beaten, intimated that he was in a gang, all kinds of things like that. And the judge was really troubled by that and encouraged plaintiff's counsel to focus on the actual allegations in this case. So the idea that Davenport lied on an employment application, the judge, it certainly wasn't an abuse of discretion to say, even if that had some marginal relevance in showing that Davenport lied, lying on an the judge was certainly within his rights to apply 352 and say that any minimal probative value was outweighed by the risk of undue prejudice. And the undue prejudice was manifest as shown by plaintiff's counsel's own questioning of Davenport at trial, talking about beating women and gang membership and all kinds of things that had nothing to do with the case.
What's the undue prejudice from allowing in that someone lied on an employment application? I understand gang membership or, how many women have you beaten, that kind of thing, but what's the undue prejudice?
Two things. First of all, you lied on an employment application about what? He was accused of lying on an employment application about a felony record. So that would bring in the fact that he had been accused of felonies. Okay, well, what kind of felonies? And then that opens the door that the judge wanted to keep closed, and quite rightly so. And then second, because whether someone's honest on an employment application has nothing to do, or very little to do, with showing that they're the kind of person who disseminates nude photos without someone's consent. And again, it's important to realize that even if that were an error, an evidentiary error, which it wasn't, there can be no prejudice from this. Davenport himself wasn't really alleged to do anything, or if he was alleged to do something, which I suppose was hand off the photos to Solaris, the jury independently found that Solaris didn't distribute any photos. So there can't be prejudice from that ruling.
Well, my understanding is that the reason why, I understand the 352 argument, but in terms of why it's relevant, Mr. Davenport was an important witness in terms of whether he had a relationship with Washington, whether he ever received the nude photos, right? So he's saying, I did not receive the nude photos is powerful evidence that what Ms. Washington is alleging that Solaris did is not true. So for credibility purposes, someone lies on an application, that has some relevance. I understand your argument about 352. I will look back at the transcript, but I'm curious, the argument ever, I know there was discussion about whether the very old felony conviction should come in. Was there any discussion about sanitizing it and just asking about?
I don't recall that, Your Honor.
applications?
As I stand here, I don't recall that. When I get back to the office, I can check. I don't recall a discussion like that.
Yeah, well, and we can check. I didn't recall that. I do think it's in the brief, just as a sentence, that that was one of the issues, and the other whether.
And it kind of, at trial in the moment, it got jumbled together with the whole discussion of his felony record and the judge's concern that the case was being tried by plaintiff's counsel as if it were a referendum on Mr. Davenport's morality, which it shouldn't have been. Something else I wanted to emphasize in terms of why any evidentiary error can't have been prejudicial is that the best evidence in this case about what happened would have presumably been the original text message of the nude photos that was Ms. Washington says was sent to her, but she disposed of her phone after she was sued. And based on that, the judge instructed the jury on spoliation and that it could find that if she willfully destroyed evidence, which plaintiff's counsel is not contesting on appeal and really can't contest on appeal given the trial testimony, that it could infer that the destroyed evidence would have been bad for Ms. Washington. So Ms. Washington came to trial with these grainy photos of unknown provenance. She doesn't know the number. She says she speculates that Solaris used an app to conceal her true number, but she doesn't know who this 909 number is. The jury was entitled, especially under the spoliation instruction, to say, you know what, that I don't think this happened, or plaintiff's counsel didn't, or plaintiff didn't carry their burden of showing that it happened. So that is independent of any of whether Mr. Davenport's believable. Plaintiff has to jump through a lot of hurdles to get to where they want to get to. They have to show not just that Davenport's lying, but also that Solaris is lying, and also the fact that Ms. Washington destroyed her phone. That doesn't matter. So the jury was well supported in finding that these photos were never circulated. Briefly on the time limits, this is a textbook case of proper time limit handling by a trial judge. The judge solicited from the parties opinions about how much time was needed for trial. There was no objection when the judge said 25 hours for each side. The judge warned plaintiff's counsel over and over again as the trial was proceeding, hey, you're using a lot of time. Here's how much time you have left. That's all over the record. When it looked like plaintiff's counsel was going to run out of time without being able to even call their own party witnesses, Washington and Glasgow, the court gave plaintiff's counsel 6 more hours. That's the opposite of an inflexible court pursuing efficiency at all costs. That's a court trying to, as California Crane School says, once the trial court establishes time limits, it's important to be fair and flexible, but it's also important to enforce them, or else the court's orders don't mean anything. So the court gave an extra 6 hours. Plaintiffs blew that. And nonetheless, the court gave plaintiff's counsel more time to present closing argument because he thought closing argument was important for the jury to hear. So this was a case where the court worked with plaintiff's counsel to give them extra time, give them a fair opportunity, but plaintiff's counsel didn't have what the California Crane School case called camping rights, where they could take however long they wanted to try the case. This was a case with fair time limits, plenty of notice, flexibility. And this isn't a case, plaintiff's counsel is talking about due process. This isn't a case where the judge announced, I'm just not allowing cross-examination in this case. You can't cross-examine witnesses. That would be a due process violation. But here, it's akin to a waiver of cross-examination. Plaintiff's counsel had their time to allocate as they saw fit, and they spent it on what they spent it on. And a risk of doing that is they lost time to cross-examine. That's something that the California Crane School case talks about in a footnote, where they say, hey, if you blow your time before cross-examination, that can happen.
Do you have any further questions?
I have one question.
Go ahead.
I know we're short on time. Quick question. On the examination of Ms. Sims, when plaintiffs were trying to bring out her possible racial bias against the plaintiffs, and the judge asked the question, what's your racial identity or ethnicity? You in your brief cite to some federal cases that say it's relevant. I do find that a troubling question from a judge. And I guess I'm curious, are there any California cases on that?
I couldn't find any California cases on that issue. What I was trying to show in the brief, I guess, is that the judge here didn't suggest, and it would have been legally erroneous for the judge to suggest, that a member of a racial group cannot, as a matter of law, discriminate against a member of the same racial group. that proposition is legally wrong, but the judge didn't suggest that.
Although the judge, by asking the question, I mean, no, it would be irrelevant to ask Ms. Sims what her racial identity was if it didn't have some relevance.
Well, and what the federal cases I cited show is that at least those courts think it's relevant because experience shows, or it would be a rational conclusion, that a member of a given group is less likely to discriminate against a member of his or her own group than someone from a different group. So that's why it's relevant. It's not dispositive. But when the question from plaintiff's counsel says, did you not believe her because she's a Black woman? And the judge then says, well, wait a minute, Ms. Sims, what race are you? The judge didn't say, well, and therefore you can't have discriminated against her because you're from the same race. Didn't say anything like that. It's just adds information to the mix that the jury could find relevant. And in any case, it wasn't prejudicial. Ms. Sims' testimony had nothing to do with the core issue in the case, which is, were these photos circulated at all, which the jury found they weren't, or was she retaliated against, and the jury found she wasn't, or both of them weren't.
Very good. Thank you.
Thank you, Your Honors.
So, Ms. White, you will have 3 minutes for rebuttal.
Oh, so Your Honors, while it's on my mind, counsel had brought up the employment applications. It's on pages 1554, 1557 through 1566 of the reporter's transcript. And I just want to name that the issue with the convictions was significant. Every case, just because it's a bad fact, it doesn't mean it's more prejudicial than probative. I agree that the facts of this case are not good, but that doesn't mean it's more prejudicial than probative. The plaintiffs lived through what they lived through, and the facts are what they are. And they promoted Mr. Davenport and Ms. Solaris after knowing of the conduct, not just as to Ms. Washington, but as to Ms. Martin too. And there was also a TRO that had been sought by Ms. Solaris against her co-defendant, which the court also excluded. The court had also asked a question about, I think it was in reference to Ms. Jenkins. And I found it during the break. Or was it Ms. Martin? The court limited the Me Too evidence from Jenkins, Martin, and Rickett as hearsay. And the examples are, if you go to the reporter's transcript as to Jenkins, Ms. Jenkins was cut off at pages 3996 through 3998. And the court did allow limited testimony as to Ms. Martin's relationship, but the pattern meaning of it was restricted by the court. That prevented us from being able to show the hostile work environment. And as to Ms. Glasgow and Ms. Flowers, their testimony was excluded as hearsay as well, and proving the heart of the case. And so the jury basically saw fragments of the story, but not the pattern. I don't know if Your Honors have any other questions.
I see no further questions.
Thank you, Your Honors.
Very good. Thank you. The case is submitted.